Welcome to the Expert Network Team podcast,
where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business nature.
We hope you will find our content useful as well as entertaining. The Expert Network team consists of Karl Frank of A&I Financial, Mike Miller of Miller & Associates CPAs, Jeff Cromendike of Security First Insurance Agency, and I'm Nathan Merrill. I'm an attorney at Goodspeed Merrill.
Together, our independent team combines our expertise to provide you insights and solutions, some straightforward, some profound, for real-life opportunities we see on a daily basis. We hope you enjoy the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's info at expertnetworkteam.com.
And we encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Now on to today's podcast.
Welcome to today's podcast. I'm Karl Frank with A&I Financial Services, and with me today I've got Nathan Merrill with Goodspeed Merrill. How are you, Nate?
I am I'm doing well.
Great.
Summer is almost over.
I can't believe it, man. It's good. It's good. It's not 100 degrees outside.
Yeah, and we got the air conditioning working over the building now, so everybody can work until the wee hours of the evening.
Oh, yeah, crack the whip.
Yeah.
Speaking of cracking the whip, we've got John Sauer, attorney at Goodspeed Merrill. Hi, John.
Hi, how are you guys?
We're doing great, man. Thank you so much for being here.
Of course.
Today we're going to talk, John is our expert. John's going to talk about employment law in Colorado and some very big changes which are happening that employers need to know about regarding non-competes. And non-compete agreements are a big deal for all of us in the professional services industry. And basically, I mean, it's upending a lot of what has gone on in Colorado in the recent past. And so we've got a lot of questions for John. John's got a lot of answers, and hopefully we're going to find a way to make things actionable for our listeners. So.
Sure thing. And John, we talked a little bit about this ahead of time. I don't think we need to get into the nitty-gritty, but I think there's some debate whether this was needed legislation or not, so it might not seem intuitive to folks as we work through some of these new provisions. You know, some of the questions I asked you, like, was this being abused? Was this a problem? And you mentioned that at some levels there probably was some abuse, but probably unenforceable abuse at best. But why don't you talk a little bit just initially about some of the key updates that have come through, and maybe any other intro on the issue you want to set the stage with.
So at the highest level, a non-compete, what does it do?
So non-compete is an agreement typically between an employee and an employer. Obviously, it arises in other circumstances like the sale of a business or something like that. But primarily in the employment context, it's an agreement that restricts the employee from engaging in particular activity. And the most important restrictions are the post-employment restrictions. So you can have a non-compete that is effective while the employee is employed, and then the following employment is what gets regulated more. There's other things that would prevent an employee from competing while they're still employed.
It'd be like the moonlighting provisions and stuff like that.
Yeah, moonlighting provisions, duty of loyalty typically prevents some of those if there's a conflict of interest or other issues arise, but the post-employment restrictive covenants related to competition. And there's two primary things that are changing here. The first is just a general non-compete. So you kind of have to think of non-competes as a species. You have a general non-compete. So for instance, say you sell cars and your employer doesn't want you to sell cars at another location. They would try to enter into a non-compete with you to prevent you from going somewhere else, taking your knowledge and skill and everything else that they built and paid you to learn and go work somewhere else. That's fine. That's one type of non-compete. I'm not saying that's legal, as a lot more facts need to be laid out to figure out the enforceability of that. But in terms of the species discussion, there's another type of non-compete that's been identified specifically as a species within a couple of cases in Colorado, and that's a solicitation of customers non-compete. So that's separate from there's a different type of provision that shows up in these agreements, non-solicitation of employees, which would be an employer trying to restrict an employee from, don't take my other employees if you leave. Those are always enforceable. There's not any significant legislation around that at this point, not something to be concerned about.
Even duration-wise?
There's cases out there that say that it's an enforceable contractual provision. There might be antitrust issues that arise with that. There might be some, illegal trade issues that could arise there. But for the most part, that issue is fairly well settled in Colorado, that non-solicitation of employees is likely enforceable without much analysis. The non-solicitation of customers is considered a subspecies of non-compete because it effectively restricts your ability to go out, restricts an employee's ability to go out into the marketplace and try to use those client contacts that they made their prior employer to generate or build their own business.
Or skills or know-how or anything like that.
Sure.
So the laws got weaker.
For purpose of enforcement, yes. So
stronger, but you could say it's labor favorable.
Yes.
There you go. Stronger for the labor, weaker for the employer.
Yes. So non-competes are always riddled with problems. Even before this change in law, I mean, you had to do a pretty deep dive analysis into whether the person met a statutory exception to the non-compete, the Colorado law that voids all restrictions on competition. And then you'd have to do an analysis with respect to geographic scope, business scope, and time. So you can't have a non-compete that lasts forever. You can't have geographic scope that's everywhere sometimes, and you can't have, any business. So
those are the pre-existing limitations.
Yes.
And to be clear, because some folks might be panicking right now, pre-existing agreements that were compliant or at least enforceable under prior law don't need to be changed or updated to meet the new requirements. What circumstances might necessitate that? Like if you re-up a new contract, do you have to update the old non-competes, or are they just grandfathered in regardless of the ongoing relationship?
So if you have a current non-compete with an employee, it's grandfathered in under the old law, the law that was in effect at the time that contract was entered into. And the new law only applies as a prospectively. So any non-compete you entered after August 10th, 2022 is affected by this change.
So if you had a prior agreement that had a non-compete in it and you modify the terms of that agreement, it's not considered a new agreement?
If you modify the terms of the agreement,
like compensation and benefits, and if it was like embedded in a employment agreement.
If you're changing the terms of the agreement, it becomes a new agreement, right?
Okay.
So it's not like if you give somebody a raise, you have to give them a new non-compete. It's that, if you enter into a different type of employment relationship with them.
Let's say I've got a 5-year contract with an employee to do something, and we go in and we change, whether it is the compensation, it's the job description, it's the work location, some terms of that agreement. If we modify this happened with 409 Cap A with deferred comp arrangements, which was a federal issue. But if you went into a deferred comp arrangement after 409 Cap A and made any modification, it was considered a new agreement that needed to comply with 409 Cap A. You're saying that's kind of how this applies too, is if you resurrect an old agreement, make it new, you're going to have to update all your non-compete provisions.
Effectively, yes. So I think since this is so new, there's no case law on this, and there's no statutory language on this that addresses the circumstance that you're setting out here. But if you have clear amendment provisions within your employment agreement that say, this can be amended in writing, accepted by both parties, and all it is an amendment that amends something that's not the non-compete, I think you have a good argument that the non-compete is still effective under the old law. But at some point, right?
But if you made amendments to affect the scope of the non-compete, then you're changing the specific provisions of the non-compete, and therefore it's a new non-compete.
Yes.
Okay.
Yes, and then you need to be in compliance.
Awesome. Well, you'll come back and update us if that changes, but
yeah, of course.
Well, I'm really scared and excited to learn how they got weaker for employers. What changed in these ways?
So maybe it'd be helpful to kind of give a little more context around the impetus for this. So one of the things that happened is about 5 years ago, there was a case that involved Jimmy John's basically requiring all sandwich makers to enter into a non-compete. And sandwich makers are making
Highly skilled employees.
Yeah. They're making sandwiches, and they can't go across the street and work for Subway if they get a 50-cent an hour raise. And I think that that was offensive to some people in the legislature, and that prompted a lot of, let's look at this issue. And they were looking at it at a federal level through the FTC. They're trying to determine, whether there's a need for federal restrictions or limitations on non-competes. That's still in process. But at the state level, one of the things that has also happened is that there's an open question on non-competes with respect to jurisdiction and venue provisions. And one thing that has made that put a lot more pressure on that provision is remote workers. So what a jurisdiction and venue provision within an agreement does is sets where the case would be heard if there's some sort of enforcement action and what law controls that case. So a lot of employers for a long time always incorporate in Delaware because they've got the most business favorable laws. Always do your non-competes. Delaware law is the most favorable to employers. Well, one of the things that happens is sometimes these businesses have no connection to Delaware. The employee has no connection to Delaware. And under those circumstances, it doesn't make a lot of sense for Delaware to be the forum state or their law to control a relationship that's occurring thousands of miles away. So among the changes, right, there's been several changes, and we're talking about primarily the changes for employment law purposes, is that courts, there was not a very clear decision within Colorado courts as to one exception that would allow the enforcement or the existence of a non-compete, and that is for management and professional staff to management, or executives and executive staff, because it's not really clear what executive staff is. Within a business, even large business, every employee could be considered staff to the executives because the executives run the business. That's at least one argument. And one of the things that, at least I think the perspective here is that kind of opened a large loophole into whether the law was in, whether you could just write a non-compete for anybody. I mean, a sandwich maker is effectively staff to the executive, professional staff to an executive at the sandwich shop. So for what it's worth, one of the things that has changed dramatically is they put in salary thresholds. So I talked a little bit about these different kinds of non-competes. You have a general non-compete where it's you can't go work for one of my competitors for a period of 2 years, within 50 miles of my business location. That's a generalized non-compete. And then the specific type of non-compete, the non-solicitation of customers, they put in two different salary thresholds. The first is it's $100,000. It's $101,250 is the salary threshold as of 2022 for that type of generalized non-compete to be enforceable, and that's tracked based on inflationary numbers through the Colorado Department of Labor and Employment Statistics Division, Labor and Statistics Division, and every year that's going to change. It's going to, more likely than not, it's going to go up. It's certainly going to go up in 2023 based on our inflation numbers, that type of thing. So for the other type of non-compete, the smaller don't take my clients type non-compete, it's 60% of whatever that highly compensated number is. So in this instance, it's $60,750. And the reason for that difference kind of makes sense to me because don't take my customers is a lot more limited than don't go work for somebody that is in my same industry or same space. So those are the primary changes is you can't do this executives or professional staff. You can't slip in a non-compete there. And then there's additional requirements related to notice. So an employee the non-compete restrictive covenant can no longer be buried in the middle of an employment agreement. You have to provide direct notice to the employee. You have to have the employee agree that they've received notice. Yes. And then you typically have the non-compete restrictive covenant as a separate document in addition to a regular employment agreement.
Seems like we're learning a lot from California here. I've seen a lot of that, like whenever you have to waive jury trial in California, you have to actually initial that section, but it sounds like the government's playing a little protective here for the little guy.
they're building in a huge number of trapdoors. So in terms of getting a call from a client saying, this person's going to compete against me, I need to enforce this, what do I do? The analysis is no longer going to be, is there a statutory exception? Do all these, scope questions, do they line up so that we're comfortable enforcing this? They're now more, have you complied with the notice requirements? What's the date of the agreement? Where, what did this person do for you? It's going to become a much deeper dive into the enforceability. And truthfully, it is very difficult, even under the prior law, to enforce a non-compete, because you start talking about the costs associated with doing so. You can't give it's difficult to give very absolutist answers as to whether they're enforceable for an employer. From the employee's perspective, you can find absolute answers, like there's no way this is enforceable, and I've provided that guidance to executives.
I mean, maybe just trying to look on the bright side of this for a second, from a pro-business point of view, being a business owner, couldn't you also say that at least you have a clear path to enforceability too, to say, hey, I checked all the boxes, now I have a much more definitive route to enforcement?
Yeah.
Therefore, it might cost less to enforce.
I think that's a great way to look at it as well. I mean, the truth is if you have checked all of those boxes, you're now in a deposition. You could be in a deposition deposing the employee, and you can say, well, didn't you receive separate notice of this? Is this not your initials here saying that you understand that you're subject to these restrictions? So absolutely. I mean, it makes it I think that the underlying purpose of the notice provision is because it could be a fairly dramatic restriction on where someone could go, and under those circumstances, the legislature wants employees to be this issue to be called out on the front end rather than, they get sued on the back end, and it makes it better for employers in the sense that their employees know what they're getting themselves into.
Well, that's the cynic in me. The flip side of that coin is the cynic in me says that even though the employee's initials are there, the fact whether they read it and understood it is entirely a separate issue.
Yeah.
But
well, of course, and it seems also really strange. I mean, I don't want to be negative, negative Nelly. I like your positive outlook on it, but there are a lot of people who could have a company secrets who make less than that threshold salary. Are they no longer able to be?
Yeah, I mean, that made me
no
think
longer...
of some of the policy implications here. They're doing this to try to protect the employee when, in fact, you could argue there's a chilling of advancement. If you have information you want to protect and you know that it's not going to be protected with people under a certain threshold, you could actually chill their ability to advance.
To get the data.
Or it might compel you to move them up. But one or the other could arguably be true. I'm just speculating at this point. But,
is that right? I mean, how do you view it, John?
So there's a lot of other protections for trade secrets, not just non-competes. And there is indeed very, very painful and expensive litigation you could initiate against somebody if they took your client list and tried to start and run their own business or took it to a competitor. And it doesn't necessarily just have to turn on whether they're engaging in competitive activities, right? Non-competes are one tool in the suitcase of how do I protect myself from the rogue employee. I think one of the things that's difficult, frankly, is that, and the truth is that within intellectual property, there's different levels of protection. A trade secret only holds its value if it's secret. And then the trade-off for a patent is that if you tell the world exactly how your thing works, then you get exclusive rights to sell it. Copyright's kind of in that same spectrum. And typically what the advice to employers is if you have something that you would consider a trade secret, you need to identify it. You need to make sure that you're taking all the steps to protect it from public disclosure. You need to be able to identify to your employees why it's a trade secret, and identify even in your handbook or in other agreements that you'll take action with respect to misappropriation of trade secrets. It's effectively theft of intellectual property in many ways. At the same time, right, many trade secrets are very transitory. So I've been working very closely with a client, and they said we do not need non-competes. We're not worried about non-competes because what we're talking about is we want we want our employees to know that these are important trade secrets, and then we'll come after them for a misappropriation claim. The value of what they have by way of a trade secret is probably its lifespan is maybe 3 months on the outside. And what they're working in, they're in a very competitive marketing space, and and it's digital marketing, and under those circumstances, any little change, within what you're marketing could be a big revenue boom, and then you need to change again, and then you need to change again. And so they're working with so many iterations, the value of the secret is very time limited.
And so those laws still exist, and they didn't change by this.
That's correct.
Yeah, why don't you go over what has not been affected in terms of enforceability clauses or exceptions or that sort of stuff?
So sale of a business, you're still in a position where you can enforce those.
Meaning you buy a business from someone, and that someone that you bought it from, you can say you can't do this ever again.
Yes. Primarily all the other exceptions are intact, right? It's just this one exception related to professional staff and management staff to executives. The rest of it has not changed, but the reality is that it becomes difficult to identify which exception you're trying to work something under if it hasn't been identified. And so sometimes I'll get a non-compete that's 10 years old, and it's like, well, how does this work, and does it fit in? One thing that becomes an issue with these is that, especially the older non-competes, is if there's case law out there that says if the non-compete was unenforceable at the time that the person signed it, because of their position, and then they later moved into a position in which it would be enforceable, it's always been unenforceable. It's not voidable. It's always been
an issue.
Yeah.
So speak to that, because we talked a little bit about that beforehand. Is this new statute requires not only that you be compliant at the inception of the contract, but also at the point of enforceability?
That's exactly right. So because of these salary thresholds, if that's the basis for supporting the reason that you have the non-compete, the salary thresholds are tied to the pay calc order issued by the Division of Labor and Statistics, and that will increase over time tied to inflation and other calculations that they do. So currently, like I said, it's 101,250 for the generalized non-compete, but that'll go up. And when the person signs the agreement, they need to be paid at least 101,250 if it's generalized non-compete. And then when you go to enforce it in 5 years, whatever that highly compensated employee number is under the CDLE's guidance, they need to be making that amount of money at the time that you try to enforce it. It's another trap door, because if you're not paying them the right amount when they sign it, it's always unenforceable. And if it's enforceable at the time they sign it, but you don't keep up with the pay calc order amounts in terms of wage growth, it's suddenly unenforceable.
What about, is this pay calculation all just W-2 wage base, or what benefits, retirement, like what factors into the overall test threshold? Equity compensation?
It would not include equity. It would not include benefits, but it would include commissions. So you can have a salary person with commissions. It's all remuneration for work, which typically doesn't include benefits and doesn't include.
What if they suck as a salesperson and they never hit the threshold based on commissions?
I mean, it creates a lot of problems with respect to the salary thresholds. And I can imagine, you have somebody that's making the salary threshold at the time that they sign it, you do your due diligence, and then you think you need to go enforce it, but they weren't making that much when you go to enforce it. Maybe you just give them $10,000 bump and then you sue them. I don't know. I mean, does that satisfy?
It's going to be a question. Just falling out of compliance, can you cure it?
Yeah, there's not any indication as to that.
Any indication as to you can or you can't?
There's no indication. Right. So.
Sorry, now you know what conversations are like around our law firm. If
any of you ever wanted
insight into law firm discussions, this is me and John right now.
I love it, right? Well, it's good that you guys think of all the details. I mean, there are a lot of gotchas there, and it sounds to me as a business owner that the next time I make a hire, I'm going to have a new non-compete drafted.
Yep, absolutely. And it's, we've updated our forms in accordance with this. We've started working on a white paper to distribute to our clients so they kind of have an idea. Hopefully it's not too detailed in the sense that it's like, just send us your agreement, we'll look at it and fix it. I'm happy to do that. But overall, yes, this is an enormous number of trapdoors.
We're obviously bringing this information to the public right now. What would you say the general awareness of this issue is amongst the business community? Has it been dispersed through chambers and associations and that sort of thing, or
I've seen
passed quietly in the darkness of the night and slid in?
I don't know. On some level, I don't know what the advertising efforts are on the legislature to say we're making these changes. I don't see it. I know from my contacts, because of the industry that I'm in, that people know about this and there's some conversation, but I got a call to enforce a non-compete recently and happy to work with this person. And I say, this is good, but I want you to know about this change in the law. They're like, oh my gosh, they changed the law. And so now we've got to re-up their non-competes. And so I would say very few
Pretty
people
low
know about this.
So if we had one of those, what do they call those banners that go across the screen? The chyrons?
Oh, is that a
It'd be
chiron?
breaking news.
Oh,
This is a
right.
breaking news podcast. So imagine yourself a little chyron going across the
like
bottom
it.
of the screen.
Right.
There were a few years there where everything seemed to be breaking news. I think
Everything.
they've gotten away from that.
I think
I don't know.
everybody's worn out from breaking news.
It seems like it's still that
But this
dramatic,
is
though.
this is legit breaking news.
For
You heard
business
it here
owners, it's a big
first
deal.
on the
That's
Expert
right.
Network Team podcast.
Our purpose in life is fulfilled.
Well, and when you're getting it first on the Expert Network Team podcast, it's probably too late. I'm just kidding. Because I don't know that this one's going to come out for a couple of weeks.
We'll find out when it comes out. We do our best as a small company. To
We
get
are not a
things-
news
but
organization.
we are
We're
definitely
an
not.
information organization.
We're definitely not running this live
Right.
on the day we're recording it.
One other thing I wanted to mention by way of changes, because you guys are calling me Negative Nancy or a wet blanket or whatever, but that's my job as an employment attorney. They've
I'm
upped
just glad I get to call him Nancy now.
they've upped the criminal penalties now, where if you actually and they call it an unfair labor practice, you could get prosecuted and you can have to pay significant fines and you can go to jail if you are using a non-compete that is is invalid.
Wow,
So
that's scary.
What? Okay. That,
Is not good news.
no.
I don't
You
even
threw
wanna
that
be-
in right at the end?
I don't even.
Negative Nancy?
I don't even want to think about
So wait,
how they would know.
So what?
or make the
That's a
case.
new provision.
So there's always been criminal penalties associated with it. I was actually shocked because some of my contacts that I call to know like the deeper ins and outs of employment law were like, "There's never been criminal penalties." And then we went through it. I sent them all the links from the old law, and they're like, "Oh my gosh, there's criminal penalties before." Well, they've just upped them, so you could do a year in jail potentially. I would be
Who would prosecute that?
the attorney general or district attorney potentially.
Have they ever?
I've never heard of it. I've
Okay.
never seen it, but that captured a lot of attention. I think even outside the legal community, because Colorado is one of the only states that would criminalize the knowing use of an invalid non-compete.
I do not recall. I have no recollection. Anyway,
Did you just listen to the Expert podcast, Expert Network podcast?
Yeah, it
Now
is-
you know.
It's intimidating, isn't it? Yeah, that's that you want to get your laws, you want to get your lawyer in line, and get your stuff lined up and be legal. Life is too short to even face a criminal accusation from an ex-employee. That's ridiculous.
So it's very unlikely to ever be enforced, but I think that at least the impetus behind that is employees, they need a job, they want to sign the papers, maybe they
Right.
don't read them, and then
Right.
and whether they know, and I mean, this I can see how this would be a strategy is whether it's enforceable or not. If an uninformed employee doesn't know any better, it might still chill their activity seeking new employment. So again, it gets to are you maliciously and willfully, acting in contravention to the law just in spite?
yeah.
Ouch. Okay, so that was a
Throw 'em in
pretty.
jail. Can you imagine all those employers sitting in jail rotting? Good for them. Just kidding.
On that note, what else? What other big bomb are we going to drop here at the end of this podcast on the enforceability of non-compete
Yeah, you got
agreements?
anything that can top that?
I think that's it.
Oh,
There's
That's
cash
pretty big.
penalties, but who cares about the money?
At a certain point, you'll probably settle especially if you're facing criminal charges.
yeah. I mean, that would be worthy of a separate discussion. What's it like to enforce a non-compete? Like, what does that process look like? What are the things you typically see factored in? I imagine cost and benefit.
Pros and cons.
Yeah,
Yeah.
but we can reserve that for a later discussion.
I love it. Well, John, you did a great job. Thank you so much for the expert insight. This is one we want to get out to all of our employer clients soon.
Yeah, because it's breaking news.
I wish for you all the best, and to all of
Thank
our
you.
listeners, create a beautiful day.
Yeah, thank you for having me.
Thank you for joining us today. Hope you enjoyed the information we shared.
If you enjoyed this podcast, please feel free to share it with someone else. And join us next time.
If you want to meet with a member of the team, please contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
If you have special topics you'd like to hear about, please reach out to us and let us know at the same email address. Again, that's info@expertnetworkteam.com. Thank you for joining us and have a great day. Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the firms represented, nor does it constitute legal, investment, or accounting advice, and the views are those of the professionals only.
Investment